Good morning. We're starting a new tradition. We're starting on time, which is something we don't always do. But welcome to the 14th in a series, occasional series, it appears, of discussions on the financial services industry. Today we're going to take a slight detour from what we've been talking about in the relatively recent past and really focus in on fair lending and as the title indicates, best practices for complying with the fair lending laws. Pretty clearly over the past weeks and months, almost coming on 2 years now, the thrust of the regulatory environment has been in large part Dodd-Frank and the implementation of the Dodd-Frank Act, or the lack of implementation, depends on your perspective, I suppose. And sort of the mortgage servicing issues surrounding mortgage servicers, both the gigantic case the government brought against the 14 largest servicers, plus the examination of servicers that is continuing to go on by the examination staffs of the agencies. And there's been certainly a lot of news, litigation, discussion, conversation about the general retail mortgage backed securities environment. Seems like everybody is suing everybody in this, whether it's the sellers, the buyers versus the sellers, it's the mortgage insurers versus the packagers. Apparently, nobody realized there was gambling going on in the back room, so this will be something that will be sorted out over a number of years. But pretty clearly, one thing that may be a little bit off the grid with all the other things that are floating around is the continued, and I don't want to say re-emphasize, I want to say continued focus on the part of the government to look at fair lending. This has been something that's been there. It's an area that the government has spent a fair amount of time focused on, and today we're going to try to do a fairly in-depth analysis of just what the government's been looking at, what you can do to prepare your institutions for the examination process, as well as any issues that might come up in that process. And we're very, very lucky today to have, I think, a terrific group of folks who've got a great deal of experience in the fair lending world. Let me introduce my fellow panelists, if I could start at the far end. David Kogut is a principal to Charles River Associates in Washington. He's an economist and is spent a lot of time working on fair lending issues. Next to David is my colleague Jeremy Hochberg, and from our Washington office, who, along with David and Mike, have worked a great deal on fair lending issues. Next to me is my partner, Mike Marzuski. Mike probably has as much experience as anybody in the country on fair lending issues, and really is a wealth of knowledge in this whole area. So without further filibustering on my part, let me turn it over to Mike, who's going to start us off and provide us with a bit of an overview of what's going on. Mike?
Thanks, Pat. Good morning, and thanks everybody for attending this webinar, and also for those of you who are here in person. As Pat said, fair lending has sometimes taken a back seat to Dodd-Frank and some of the other highly publicized financial regulatory developments of the last couple of years. But fair lending has not really been dormant. In fact, within the last 5 years or so, the way that the agencies have examined for compliance with fair lending has changed dramatically. And I think with the creation of the CFPB, which I'll come back to at the end of this presentation, the examination and enforcement of compliance with the fair lending laws is not likely to lessen anytime soon. 5 years ago, the state-of-the-art fair lending monitoring tool was a high-level screen that analyzed HMDA data for outliers, and if there were no outliers present, the examiners generally closed their examination file and moved on. Today, that's not the case, and if you haven't had a fair lending examination at your institution for a while, you may be surprised at how robust the fair lending analysis is. The agencies now use very, very sophisticated computer models to do regression analyses to determine whether there are statistically significant disparities between the way members of protected classes under the fair lending laws are treated versus the way that the non-protected applicants are treated. And David is going to get into some of the regression analysis detail later in the presentation. So there are a lot of good reasons to be diligent in trying to have your institutions comply with fair lending. First and foremost, it's the law. It's also good business practice. There was a time 40 years ago when the white male-dominated banking industry didn't think single women should be able to obtain credit, or didn't think minorities were good credit risks. I think that history has proved those outmoded notions wrong, and I think a lot of our institutions that we do business with and represent believe it's good business to have a diverse customer base. And I guess lastly, compliance with fair lending laws is important because the failure to comply has some serious consequences looming. The agencies have an arsenal of arrows in their quiver. They can impose injunctive relief. They can require restitution. They can impose civil money penalties. Anyone accused of unlawful discrimination suffers reputational risks, and it also affects your ability to expand geographically if you have a fair lending issue that results in a downgrade of your Community Reinvestment Act or your compliance rating, or results in a referral to the Department of Justice or HUD. In effect, you're put in the penalty box until you have been able to clear your fair lending issue. There are basically four fair lending laws and regulations and guidance that we're going to touch upon today. The first is the Equal Credit Opportunity Act, which is implemented by Regulation B. The second is the Fair Housing Act, which is implemented by regulations published by HUD. The third is the Interagency Policy Statement on Discrimination in Lending, which was first promulgated in 1994. There's a lot of good information in that policy statement, but the way that policy statement is enforced today is radically different from the way it was enforced nearly 20 years ago. And lastly, there's non-discrimination requirements that are contained in what are now OCC regulations. Interestingly, this is a OTS regulation that prohibits discrimination not just in lending but in all aspects of banking products and services. When the OTS was subsumed in the OCC last July, the OCC recodified the non-discrimination requirements in 12 CFR Part 128. Interestingly, that only applies to thrifts. It does not apply to national banks because it was an OTS regulation and the OCC did not amend it to include national banks at the time that it recodified it. The Equal Credit Opportunity Act is probably one most people are familiar with. It prohibits discrimination in any aspect of a credit transaction. What's particularly important is to pay attention to any aspect of a credit transaction. That That means it covers everything from advertising to your first interaction with a consumer, all the way through servicing, foreclosure, repayment of a debt. And I think a lot of people focus on ECOA compliance from the perspective of denials or pricing or terms and conditions, but we've seen cases involving advertising that was considered to be discriminatory, applications and the quality of assistance that borrowers have gotten up front that have been deemed to be discriminatory by agencies. So it's important to take an expansive view of where in a credit transaction you are and how you're treating people to make sure that similarly situated people are being treated similarly. The Regulation B is now under the purview of the CFPB, which recodified the Fed's Regulation B without substantive changes. They have not modified that regulation or really issued any guidance or interpretation, so it remains to be seen how the CFPB is going to interpret the ECOA and Regulation B going forward. The Equal Credit Opportunity Act prohibits discrimination on the basis of race, color, national origin, religion, sex, marital status, or age, and it also prohibits discriminating against somebody because they rely on public assistance. There are certain exceptions. The ECOA does permit creditors to favor elderly applicants with more favorable terms and conditions than are available to other similarly situated younger individuals. The second major federal fair lending law is the Fair Housing Act. It prohibits discrimination, again, in all aspects of a residential real estate transaction, including the granting of credit, and it prohibits discrimination on slightly different bases than the ECOA. It prohibits them on race and color, national origin, religion, sex, familial status, which isn't covered by ECOA, and disability, again, which isn't covered by ECOA. The ECOA and Fair Housing Act both apply to residential real estate mortgage transactions, but ECOA also applies to all types of lending, including non-residential lending. So, for example, if you have a female-owned small business that comes to a lender with an application for credit, that lender can't turn the application down solely on the basis that they don't make loans to women-owned small businesses or they don't make minority-owned small business loans. So it's important. A lot of people forget that ECOA does not just apply to consumer transactions. The OCC has published a list of examples of discriminatory conduct. Among them are failing to provide information or providing different information regarding credit availability with respect to application procedures or lending standards, or discouraging or selectively encouraging applicants. Many institutions employ mystery shoppers who visit branches and seek information about loans, seek assistance with filling out applications for loans to see if white mystery shoppers are treated differently than mystery shoppers who are members of protected classes. So again, it goes back to the point I made earlier about being careful in all aspects of a lending transaction, including the initial contact that somebody has with bank lending personnel. The OCC also believes that making loans on different terms, including the amount, interest rate, maturity, or type of loan, when similarly situated borrowers are involved, can be discriminatory. A number of years ago, the Department of Justice entered into a consent order with the finance company of a bank holding company because it was offering the same credit product to borrowers, but it had two sets of forms, an English language form and a Spanish language form. it turns out that the Spanish language forms were more onerous for the exact same product than the English language forms. So the finance company sub was cited for discriminating against Spanish-speaking applicants, entered into a consent order, had to pay restitution, and other forms of relief were required. Another one of the examples of discriminatory conduct in the OCC Fair Lending Handbook relates to treating borrowers differently in servicing loans or invoking default remedies. I've been on the speaking circuit for a number of years saying that sooner or later the regulators were going to wake up to the fact that servicing could present some fair lending obstacles. Are minorities being given the same kind of notices as non-minorities? Are members of protected classes being given the same loan modification opportunities as non-protected class members? Pat was talking a little while ago about the 14 largest mortgage servicers who are undergoing foreclosure loan lookbacks because of foreclosure practices that occurred over the last several years on a fairly widespread basis. The purpose of that consent order and the look back is to see if individuals whose homes were foreclosed or are in the process of being foreclosed were financially harmed. But when you're looking at something like financial harm in a UDAP or restitution situation can often morph into a fair lending issue. If minorities were adversely affected at a disproportionate rate than white borrowers who went through the foreclosure process, I wouldn't be surprised to see one or more of these 14 servicers also facing a fair lending issue down the road. There are three different types of discrimination that the regulators look for typically. One is overt discrimination. You don't really see overt discrimination a lot. If an institution had a policy that said we don't make loans to Asian Americans, that's clearly an overt policy that would discriminate against a member of or members of protected classes. Most institutions don't do that. Occasionally, you'll find an institution that has a protected class factor inadvertently in their loan policies. It's not really necessarily intentional, but that's not where most of the fair lending issues come up. Disparate treatment is another form of discrimination that is more commonly ferreted out by the regulators, and that can be evidenced by statements revealing that a creditor explicitly considered prohibited factors, or it's where differences in treatment can't be fully explained by legitimate non-discriminatory business reasons. Disparate impact is, again, another common form of discrimination that regulators look for, and that's found where lending policies are applied equally but nevertheless disproportionately disadvantage members of protected classes. The example I always give is if you had a credit score system that gave bonus points for having blue eyes. That has nothing to do with creditworthiness. It's a facially neutral policy. It's applied to all applicants, but the fact of the matter is members of certain protected classes are less likely to have blue eyes than white males, for example. So that would be an example of a facially neutral policy that could have a disparate impact on members of protected classes. The disparate impact theory is also known as the effects test, and Regulation B expressly states that Congress intended the effects test concept to be applicable to a creditor's determination of creditworthiness. There aren't any cases interpreting the effects test in the lending context, because the fact of the matter is, up until now, financial institutions have been loath to litigate fair lending cases. Especially those cases that are brought by regulatory agencies or by the Department of Justice or HUD, those cases tend to settle if it's a DOJ case resulting in a consent order, if it's with a regulatory agency in some sort of an enforcement order. But there are effects test cases in the labor context, and in the labor context, courts have typically employed a burden-shifting approach to determining whether there has been a disparate impact. And by that I mean it's the plaintiff's excuse me. By that I mean it's the plaintiff's burden to make a prima facie case that there has been discriminatory conduct, and typically that's done by some sort of statistical analysis or regression analysis. The defendant then has the burden of proving or of offering a legitimate business justification for the complaint about conduct, and then the burden shifts back to the plaintiff to prove that there was a less intrusive alternative that would have accomplished the same business objective. The Department of Housing and Urban Development has proposed a rule on the discriminatory on the effects test standard that would shift that burden of proof. In the HUD's proposed rule, the plaintiff would have the prima facie case burden. The burden of persuasion, the final burden of proof, would rest with the defendant. The plaintiff wouldn't have to make the subsequent finding. So there's been a lot of commentary submitted about that proposed ruling, and hopefully HUD will adopt the same sort of standard that most of the courts in the labor context have adopted. The policy statement on discrimination lending that was issued by the banking agencies in 1994 is included in your materials, so I'm not going to spend any time on that right now. And as I said, the OTS non-discrimination requirements have been recodified, but they do not apply to national banks. If there is a fair lending problem identified by a regulator or the DOJ or HUD, what are the sanctions that can be levied? As I said at the outset, enforcement actions can include injunctive relief provisions, restitution, civil money penalties. If the transgressions were serious enough, the bank agencies have removal powers and other sanctions that they can impose. HUD can bring a case to a hearing before an administrative law judge, and ACOA and Fair Housing Act violations can be enforced by the Justice Department through a civil action. Typically, the Justice Department conducts an investigation, and if it believes that discriminatory conduct has occurred, it will offer parties the opportunity to enter into a consent order, which is what most financial institutions do because of the reputational risks associated with litigation. When a client comes to us and asks for our assistance on fair lending, first they come to us in two different contexts. One, they're proactively looking for assistance, or two, they come to us because they're in the middle of an examination or they've gotten a complaint and someone has alleged that discriminatory conduct has occurred. First thing we do is find out what their fair lending monitoring program is that's currently in place. And we find out what kind of statistical analysis they're doing, if any. We often find out that institutions aren't having any form of statistical analysis done, and one of the first suggestions we make is that they employ an economist or a statistician so that we can replicate the kind of regression analyses that the regulators are going to use when they conduct their fair lending examinations. Where we get a consultant involved, in order to establish attorney-client privileges and attorney work product privileges, we typically retain the economist or the statistician who works at our direction and under our supervision, and we then establish an arrangement so that the work product, in particular, that the economists produce can be withheld from third parties on the grounds of privilege. It may not be upheld, but at least we try and set up the arrangement so that we have a colorable claim of privilege. We also assist with investigating factual situations, developing legal arguments, and if there is a question raised by an agency or DOJ or HUD, we write advocacy pieces to those agencies to try and defend our clients from whatever the allegations are. At this point, I'm going to turn it over to Jeremy to talk about some of the proactive things that we do.
Thanks, Mike. I'm going to talk about three things today: best practices, the referral process, and recent settlements. Now, it's become standard practice for institutions to retain outside counsel, who in turn retain consultants, as Mike just explained, to engage in proactive fair lending reviews. Ideally, the retention of counsel would be at the early stages, before any compliance exams have been conducted or the regulators have flagged any fair lending issues. However, certainly at the very least, an institution should engage counsel once the regulators have flagged an issue. Now, the purpose of these proactive reviews is twofold. First, it's to discover and correct any problems before they become bigger issues. And second, it's to show that any statistically significant disparities in, for example, underwriting or pricing can be justified by non-discriminatory explanations. As Mike mentioned, the federal banking agencies use a risk-based approach to identify institutions for comprehensive fair lending exams. The agencies use Home Mortgage Disclosure Act data to identify outliers, outlier institutions that pose a high risk of fair lending violations. They also randomly select institutions for comprehensive fair lending exams. Now, while it's important to start with HMDA data, the analysis should not stop there. It's standard for consultants to prepare statistical models that incorporate legitimate credit factors such as loan-to-value ratios, debt-to-income ratios, and credit scores. Consultants then refine the models and identify any factors that are driving the disparities. Finally, to the extent that there are still disparities that cannot be explained by the model, a comparative file review may be warranted. And I'm just providing this high-level overview. I'll let Dave Kogut go into more detail on this. In addition to statistical analyses, institutions should re-examine their underwriting standards at least annually to ensure that applicants are being given an equal opportunity to obtain a loan. While some discretion is not necessarily problematic, training should be provided to promote the proper use of discretion. And any discretion should be carefully documented in underwriting policies and monitored. An institution should also conduct due diligence on and monitor the lending practices of its brokers. To avoid allegations of redlining, an institution should compare its geographical lending profile with those of its peers. It's important to note that an institution's lending profile is not necessarily its assessment area for Community Reinvestment Act purposes. Now, beyond the actions that a banking regulator may take against an institution for fair lending violations, the fair lending issues can also, and in some instances they must, be referred to the Department of Justice or the Department of Housing and Urban Development. Referrals to DOJ are mandatory when an agency has reason to believe that one or more creditors has engaged in a pattern or practice of violating the Equal Credit Opportunity Act. And such referrals are discretionary when the agency has reason to believe that a COA has been violated, but there is no pattern or practice. An agency must also provide notice to HUD, or rather alternatively provide notice to HUD if it has a reason to believe that the violation of a COA has occurred, that a violation of the Fair Housing Act has occurred, and that it does not refer the case to DOJ because there is no pattern or practice. Now, in our experience, the regulators will often view two or more violations as a pattern or practice. However, the interagency policy statement on discrimination in lending states, and I quote, "Isolated, unrelated, or accidental occurrences will not constitute a pattern or practice." Thus, more than one does not necessarily constitute a pattern or practice.
And there are cases in the labor context that indicate that have a pattern or practice, it has to be systemic. It has to be part of the core function of the business. Unfortunately, that's not the way the regulators look at it. As Jeremy said, they look at two or more violations as a pattern or practice and routinely make referrals on that basis.
And the interagency policy statement goes on to say that the regulator should take into account the totality of the circumstances, such as whether the conduct has a common source or cause within the bank's control, or to look at the relationship between the number of violations and the bank's total lending activity. Now, HUD's complaint process, HUD can receive or can decide to issue a complaint in three different ways. One, it's based upon a referral from one of the other regulatory agencies. Second would be on its own accord, and third would be through a consumer or consumer group that files a complaint with HUD. Within 10 days of receiving of filing its own complaint, HUD must serve notice on the parties, and within 100 days of the filing, HUD must complete an investigation unless doing so would be impracticable. While HUD is investigating, it must attempt a conciliation between the parties. Participation by the parties in signing a conciliation agreement is purely voluntary. In addition, HUD must refer some matters to DOJ. It must do so when the parties sign a conciliation agreement and breach that agreement, or when it has reason to believe that a person or group of persons is engaging or has engaged in a pattern or practice of violations of violating the Fair Housing Act. And once again, this pattern, basically whenever there's a pattern or practice of violations of the COA or the Fair Housing Act, it will result in or there's reason to believe that there's a pattern or practice of violations that will result in a referral to DOJ. Now, as you can see from this slide, the majority of referrals in the past 10 years have come from the FDIC. Then again, that's not surprising because the FDIC also regulates more than half of the institutions in the banking system. As you can also see from this chart, the number of referrals has risen in the past few years, reaching a 10-year high of 49 in 2010. In fact, in 2010, the FDIC made 33 of the 49 referrals to DOJ, while none of the other agencies made any more than 6 referrals. In contrast, from 2001 through 2008, the Department of Justice received only a total of 30 referrals involving discrimination on the basis of race or national origin, compared to the 26 that it received in 2010. It is also noteworthy that of the 2 referrals by the Office of the Comptroller of the Currency in 2010, they both involved discrimination on the basis of race and or ethnicity. This slide provides a further breakdown of the types of referrals that occurred in 2010. As you can see, the vast majority of referrals related to race, national origin, or marital status. Now, it's unclear what impact recent regulatory changes, that is the advent of the CFPB and the demise of the OTS, or rather the rolling of the OTS into the OCC, will have on the annual number of referrals going forward. However, since the majority of referrals have typically been by the FDIC, we do not expect dramatic changes to recent trends. Now, upon receipt of a referral, the Department of Justice has some options to make. It can decide to open an investigation. Upon opening investigation, it can threaten to file a lawsuit, which it would do in federal court, or the Department of Justice can decide to return the matter to the regulator for administrative enforcement. The referrals that are most likely to be returned generally have the following characteristics: the practice has ceased, and there's little chance that it will be repeated, or a violation may have been accidental or arose from technical violations, such as spousal signatures, or requiring spousal signatures in certain circumstances. Now, if the
Jeremy, let me ask you a question. When there's a referral, could you just illuminate a little bit on the role of the advocate in the process at the agency to avoid a referral, and the role of the advocate once it gets to the referral stage, it's at justice? What role do the lawyers, the consultants play before the agency in trying to convince them that there is no basis for in the first case the referral, or secondly if there's a referral made, there's no basis to take it any further?
That's a good question, Pat, and I guess our role in the process is to respond to the agencies or the Department of Justice, whatever the case may be, to explain why to explain away any statistically significant disparities through advocacy pieces, also providing information at the request of the regulators.
Well, and to back up a step, let's say we're in an examination and a regulator raises a question. They're going to have some basis for their assertion that a certain practice violates the fair lending laws. And it's generally going to be supported by some sort of statistical analysis. So pretty much the first thing we're going to do is ask the agency for their analysis, and then we're going to have our expert, economist, statistician, replicate what the agency has done. And if the agency has not considered certain filters that we think are legitimate filters to put into a regression model, we'll then, as Jeremy said, go back to the agency with an advocacy piece that says, we understand what you're saying, but your analysis fails to take into account the following ABC factors, when you do that, the disparities disappear or the disparities become meaningless. So we will try and determine as many different holes as we can find in an agency's position. Let's say the agency then has made the referral to justice. We will make sure that the initial submissions, whatever they were, to the agencies get in the hands of the Justice Department. We'll sit down with the Justice Department staff to try and explain why the agency got it wrong and the referral should never have been made. And then the DOJ proceeding takes on a life of its own as if it opens a formal investigation, you can expect to get an information request, which means we've got to produce documents and responses to interrogatories, just like any other litigation or investigation.
And another thing that we can do before a matter has been referred to DOJ is we can appeal a regulator's examination findings all the way up to the regulator's ombudsman.
Yeah, and I'll just add to that, when the regulator has made allegations, they're usually going to provide, like Mike said, they're going to have some statistical basis for that. They're going to provide us with their statistical output, and there's no mystery about where these numbers came from, and we can usually exactly replicate what they did to understand what might be missing from those from their analysis, and to hopefully improve upon what they had done.
Now, DOJ evaluates referrals, and it will usually the instances in which it's most likely to litigate are when the pattern of practice is not likely to cease without court action, when the protected class members harmed by the practice cannot be fully compensated without court action, or when it's necessary to bring an action to deter other lenders or this particular lender from engaging in this type of activity in the future. Now, I'm going to now turn to some of the recent cases of particular note regarding fair lending referrals and settlements. In this first matter, the countrywide financial matter, DOJ's investigation resulted from referrals by the Federal Reserve and the OTS. The complaint alleged that Countrywide discriminated by charging more than 200,000 African American and Hispanic borrowers higher rates and interest fees, or interest rates and higher fees than non-Hispanic white borrowers in both its retail and wholesale lending. It also alleged that Countrywide discriminated by steering thousands of African Americans and Hispanic borrowers into subprime mortgages when non-Hispanic white borrowers with similar credit profiles received prime loans. Finally, the complaint alleged that Countrywide violated ECOA by discriminating on the basis of marital status against non-applicant spouses of borrowers by encouraging them to sign quitclaim deeds that transferred their legal rights in jointly held property to the borrowing spouse. The settlement required that Countrywide pay $335 million, which is by far the largest settlement we've seen, to the alleged victims of the discrimination. At least $20 million of that amount must be directed to the allegedly harmed individuals who live in Illinois. And 24 months after the distribution of notification letters regarding the settlement and the ability of individuals to come forward with a claim, all remaining funds must be distributed to financial literacy programs, credit, and housing counseling programs. This next case, the Citizens Republic case, involved redlining in the Detroit area. or allegations of redlining in the Detroit area. And the consent order required Citizens Bank to provide fair lending training on an annual basis to all employees with significant involvement in residential lending. This is a typical requirement in most consent orders. Notably, this settlement did not require any restitution. Instead, it required Citizens Bank to open a loan production office with an within an African American neighborhood in Detroit, to provide $1.5 million in a special financing program, to provide $1.625 million to match grants by the city of Detroit to homeowners in certain neighborhoods, and to spend $400,000 on advertising, marketing, and consumer financial education. The last case I'm going to touch upon is the AIG case, which resulted from a referral by the Office of Thrift Supervision to the Department of Justice. The complaint alleged that the defendants violated the Fair Housing Act and DCOA when they charged higher fees on wholesale loans to African American borrowers than to similarly situated non-Hispanic white borrowers. And this was in the time frame of July 2003 through May 2006. The complaint further alleged that AIG, FSB, and Wilmington Finance, Inc. failed to supervise or monitor brokers in setting brokers' fees. Significantly, this was the first time in over a decade that the Department of Justice held a lender responsible for failing to monitor its brokers to ensure that borrowers are not charged higher fees because of their race. And with that, I'll turn it over to David Kogut.
Okay. First of all, I'd like to thank Arnold and Porter for having me here today. I'm the only economist on a panel of lawyers. Nothing I say should be construed as being legal advice, so keep that in mind. But here, the first slide is just sort of a diagrammatical representation of what, in this case, the OCC, and this is really any of the regulators, are going to look at and evaluate when they come into your institution to perform a fair lending review or a fair lending risk assessment. I'm not going to go into too much detail here. This process is really well laid out in these fair lending examination procedures, which are the 4 interagencies, and it's available on the FIFIEC website, fifiec.gov. It's only 40 pages long. It's not the most exciting read, but I think for people in this line of business, it's an important document to read, and it's not that long. But anyway, these are the aspects of your lending activities that a regulator is going to look at, and that we as consultants are going to also look at if we're putting together a fair lending monitoring program for you. It starts with access, which refers to redlining and marketing, assistance to borrowers once they've made applications. In particular, most of the problems here are with regard to non-English speakers and the extent to which, applications end up being withdrawn or not decisioned because the application was incomplete because there was difficulty with language and getting the applicant to understand what was required of them. Steering refers to steering borrowers into products that are inappropriate for them or that are more expensive when they would have perhaps qualified for a less expensive product. This is kind of less of a problem now that there's no subprime market, but to the extent that your institution has a pretty wide array of products, which is not a bad thing, you need to be aware of any instances where you have protected classes, minorities, females, elderly borrowers, or applicants are disproportionately using certain of your loan products, and it's a particular concern if those loan products cost more than other loan products. Underwriting, obviously, that's a pretty obvious thing they're going to look at, just see if denial rates for protected classes are higher than for non-protected classes. And among approvals, they're going to look at whether similarly situated borrowers are given the same prices, usually measured in terms of APR. You might also, in this aspect of the review, get into broker fees or overages and underages that get charged to the borrower. Even then, after the loan has closed, you get into servicing, and for delinquent loans in particular, in this era where there's a lot of regulatory focus on what loan modification outcomes are, regulators are looking at what those outcomes are for protected classes versus non-protected classes, and whether, for instance, among your modifications, did minorities, were their interest rates lowered as much as they were for non-minorities? Were the loan terms extended for a longer period of time for non-minorities than for minorities? And really, the goal of most of these programs is to lower your front-end ratio, or the amount of your monthly payments. So they're looking to see that monthly payments decreased at about the same amount for protected classes as for non-protected classes. All along in the process, certain of the aspects of this risk assessment or the evaluation that the regulators and we do are more amenable to doing statistical analyses than others. The obvious ones where there are well-established methodologies for conducting analyses are for underwriting and pricing, and I'll get into that a little more momentarily. For fees, even in this era where under Dodd-Frank, there is much less discretion afforded in the amount of fees that can be charged and whether those can be tied to broker compensation. For overages and underages, even though a loan officer isn't going to be compensated based on those overages and underages, there is still discretion there to either meet a price that's been made by a competitor or for various other reasons. And, so you'll have caps and floors in place on your overages and underages, and that's great. However, just having those caps in place is not enough. You need to monitor who's getting the overages, who's getting the underages, what were the amounts of those overages and underages, even those within the caps. And, usually you're going to find that for various reasons, minorities did not receive the same amount of underages that non-minorities did, usually having to do with existing customer relationships or because of, they claimed they went down the street and got a competing rate, and they're asking you to match that rate. So even with these caps in place, it's really important that these fees and overages and underages be monitored to keep you out of trouble.
Excuse me, Dave. We've been talking about what happens when a regulator raises a problem and you get an economist to replicate what the regulator's done. But we also recommend for our clients that they do proactive monitoring and that they do it on a periodic basis every quarter or every 6 months, because as Dave was just talking about monitoring these overages and underages, if you spot a trend that doesn't look good after the first quarter or after the first half of the year, you can tweak your policies and procedures so that by the end of the year, whatever anomalies showed up during your periodic prophylactic review disappear, and on a 12-month basis, you don't have an issue. If you wait till the end of the year or don't do any monitoring, you don't know if you have an issue, or if you have an issue, it may not be able to be dealt with on a timely basis.
One other thing I want to mention about broker comp, now we're in this era where, there is no brokers. If the broker compensation is lender paid, there's no discretion in the amount of that fee that the broker can receive. However, most institutions are establishing these tiered compensation structures or schedules where, on a periodic basis, a broker will choose how much, if they want 1% of loan amount as compensation or 2%. And those compensation schemes, if you chose 1%, the rate sheet you're going to be provided with is going to have lower rates on it than if you chose a 2% compensation schedule. So even though there is no discretion in the amount of the fee that the broker is going to receive, the rates that ultimately get charged as a result of that schedule are going to be different for different borrowers and brokers. And if your brokers who tend to serve protected classes are those who chose the higher compensation schedule, chose the 2% instead of the 1%, you're going to see that the rates charged to the minorities or the protected classes are higher than for the non-protected classes, even in a context where there is no discretion. And so this is it's a clear case of potential disparate impact. This is so new. This only was established in April or so that these schedules were put into place. So we don't know what effect this is having, but this is something that I think is a risk going forward. Comparative file review, as Jeremy mentioned, if we do find outcomes that look disadvantageous to protected classes and we're unable to explain those with our models, we're going to actually go in and look at loan files to see if we can find information in the loan files that would help to explain the outcome that was received by the borrower. Also, we're looking to make sure that the data that was used in our model was correct. Some institutions, large and small, they're sending you data on LTV they think is correct, but you go into the file and actually this data was not correct, and it wasn't the LTV that was used to price or to underwrite the loan. So that's another reason to do comparative file review. Doing peer analysis, this is usually done in the context of redlining. And again, I'm going to talk about this in a few minutes a bit more, but in your CRA assessment area or in your market area, it's very important to look at your lending patterns relative to those of peers, and you need to identify those peers very carefully. It is definitely not a science to identify peers, but the DOJ, if it got to that, or your regulator are going to do that for you, and you need to, if they've identified institutions that you don't think are appropriate, you need to be able to tell them, well, we don't think this peer is appropriate, but here are some institutions who we think are a bit more similar to us and are more appropriate to compare us to. One thing is, if you say, our lending or our business model is so unique that there are no institutions you can compare us to, well, that you're going to have a really hard time making that argument. The next slide, they're just a bunch of numbers. Obviously, I'm not going to go through all these numbers, but just for a hypothetical lending institution, this is a tabulation of their raw HMDA data by action taken and by applicant race ethnicity. For this institution, among conventional first lien mortgages, African Americans had about a 50% denial rate compared to a 26% denial rate for whites, for non-Hispanic whites. This, it's about a two times difference. This is just from the raw HMDA data, would likely raise some questions with a regulator, and they're not going to say, well, this is out and out a problem, but this is going to flag for them the need to go and do additional review. Here on the next slide, this is just looking again purely raw HMDA data, controlling for nothing like LTV, credit score, etc. Just looking at average APRs for this again hypothetical institution. For conventional first lien mortgages, African Americans are paying about 14 basis points more in APR than non-Hispanic whites, and again, this is not a very large disparity, but it would be statistically significant and might raise red flags for a regulator if this couldn't be explained. All right, so when we find results like this, we are going to look at your rate sheets and your underwriting policies. We want to get those in a hard copy or electronically. We're going to review those very carefully to understand what factors you're using to make your underwriting and pricing decisions. Here we've just listed some examples of the most common factors that would be used, and then we're gonna you're gonna have to provide us with this data at a loan level so that we can construct statistical models to help explain the raw disparities that we saw in the HMDA data. So you should be prepared to have this data available. It is, if you're not collecting this data, you really need to do it. Here, now we're getting more into statistics, and just because of a lack of time, I'm not going to, delve into these statistical measures too much. I will say that an odds ratio here from a raw model, that corresponds to the raw disparities and denial rates that we saw in the HMDA data in the earlier chart. So the odds ratio, which is just a measure of how much more likely it is that a minority or an African American was denied than a non-Hispanic white, that odds ratio is 2.8 in the raw model, which controls for no loan characteristics, and that is a high odds ratio and is going to be a regulatory concern. However, in this instance, for this hypothetical institution, once we control for the factors like LTV, credit score, automated underwriting decision, we're able to explain a great deal of this disparity. Is likely the case that minorities had lower credit scores or higher LTVs, and we were able to, through the regression model, to get this odds ratio down to 1.3, which, although here it's statistically significant, I won't get into what exactly that means. That is a level of an odds ratio that is going to be acceptable and is probably not going to lead to a referral. Next slide is the same type of analysis, that results that would come out of an analysis of pricing. Again, the 14 basis point disparity for African Americans is, that appears as the 13.62 coefficient estimate from the regression model. So that's just saying, again, that African Americans paid about 14 basis points more for these loans than non-Hispanic whites. Again, once we controlled for the appropriate underwriting and pricing factors, we were able to explain all but 3 basis points of this disparity, and that is a level of disparity that's not going to cause further regulatory interest. I'm going to skip that next slide in the interest of time. So one thing that one area that has been of high importance and of interest lately is redlining. And redlining, again, it refers to treating geographic areas differently based on the race, ethnicity of the residents of that area. It is not, you're not discriminating necessarily against minorities. However, you're treating a particular census tract or a particular county differently with regards to pricing, but in particular access, than you would a census tract or county where the residents are mostly non-Hispanic white. Evidence that has supported claims of redlining are that you're an institution where your market area is a given MSA, and however all of your branches are only in the non-Hispanic white areas. You've also done little or no marketing in the minority areas, or you've done no marketing in media or on radio stations in that area that would have predominantly minority listeners or an audience. You also have a lack of products or business channels that would support lending by people of lower incomes or minorities. So you think your market niche is serving wealthy borrowers with large deposits at your bank. That's might be a profitable business model. It's a business model that might cause you some regulatory problems.
Dave, in the 90s, there was a thrift out of Albany called Allbank, and they bought loans from loan originators, but they actually had a policy that said we will not buy loans in Connecticut from that are made in Hartford, Bridgeport, Waterbury, New Britain. We won't make loans in New York City above 110th Street, and they actually had this as a written policy, and that was fairly good evidence that they were redlining entire cities where there were large minority populations, and the DOJ entered into a consent order to enjoin them from continuing that kind of conduct.
Yeah, kind of getting to that, another factor that would be evidence of redlining is that your CRA assessment area is, usually good CRA assessment areas are made up of entire political areas, an entire county, an entire city. If your CRA assessment area excludes areas of a county or an MSA that are predominantly minority, that is going to be used against you. And then, of course, the most important driver of redlining findings is that you're just lending less in minority areas than non-minority areas. A recent settlement was with Midwest Bank Center. They had, without getting into all the details, they had almost all of these factors going on, allegedly by the DOJ. This was a settlement, so you don't really ever get the bank's side of the story. You just see what the DOJ had to say about this case. But among the facts were that all of their branches were in non-minority areas of St. Louis. Their CRA assessment area excluded the area of St. Louis that was mostly minority. Of the 60 census tracts in St. Louis that were 50% or more African American, they excluded. Their CRA assessment area only included 13 of those. So their assessment area was drawn in a way that excluded these minority areas. Also, they had hired a consultant who had pointed out to them that this was going on. However, they did not they didn't take any affirmative action to address these issues. And then the DOJ did do a statistical analysis showing that, for the bank, about 2.7% of their applications were from African American areas, wherefore some identified peers also operating in this market area, 10.7% of the lending activity of the peers was in minority areas. So for the peers, the proportion of their lending in minority areas was about 5 times that of Midwest banks. With that, I will turn it back over to Mike to wrap up and talk about Dodd-Frank.
Okay. In the interest of time, so we have a little bit left over for questions, I'm just going to briefly cover some of the implications of the Dodd-Frank Act legislation on the fair lending enforcement world. The Consumer Financial Protection Bureau has rulemaking authority with respect to a number of federal consumer financial laws that where authority was transferred to the CFPB last year. They have authority for writing regulations under the ACOA. As I said earlier, so far they haven't amended ACOA, and they really haven't put out any guidance on how they intend to stick closely to Fed guidance on ACOA interpretation, or whether they're going to deviate in some fashion. Significantly, while they have an alphabet soup of consumer financial laws that they've got authority for, they don't have authority for CRA or the Fair Housing Act. So that raises questions about how the regulatory agencies are going to coordinate with examinations. For example, so the CFPB has examination authority over institutions with assets in excess of $10 billion, as well as the affiliates of those institutions. But in many cases, those institutions are, well, not in many, in all cases, they're going to be supervised by a prudential regulator who has the continuing responsibility to evaluate them for CRA purposes. CRA has a fair lending component to it. Does that mean the control of the currency, the Federal Reserve Board, the FDIC are all going to conduct duplicative fair lending examinations of institutions over $10 billion? Are they going to coordinate with the CFPB in some fashion? Now, the CFPB hasn't done any examinations to date, so there's no CFPB work product to be shared. All that joint examination authority remains to be sorted out. The CFPB also has jurisdiction over certain non-bank entities involved in the real estate business, such as mortgage loan brokers and servicers. In many instances, mortgage loan brokers in particular were not regulated before, and so that's going to have a profound effect on the way the mortgage business is conducted going forward. And like the banking agencies, if the CFPB finds a pattern or practice of discriminatory conduct, it's required to make a referral to the Department of Justice. Another issue that is front and center today is the production of privileged information and attorney work product to the CFPB. The CFPB has been requesting information from banks that it supervises now, and they have requested confidential or attorney-client attorney work product information, and they've put out some guidance that said we believe that based on a 1990s vintage OCC opinion and a Hawaiian District Court opinion, that if you turn over privileged material to us, you won't lose the privilege vis-a-vis other third parties. There was long a tension between banks and their regulators over the provision of privileged material to bank regulators. And about 5 years ago, Congress passed 1828X, which permits regulated entities to turn privileged information over to their prudential federal banking agency without losing the provision vis-a-vis third parties. Significantly, Section 363 of the Dodd-Frank Act amended the definition of federal banking agency to remove the OTS because the OTS was going out of existence, but it did not include the CFPB. So, while the CFPB put out guidance that says you're not going to lose your privilege if you turn things over to us, I think a lot of institutions are concerned about that very point, and various clients have handled that in different ways. Some clients have said, we're not going to turn it over to you until there's a legislative fix where it's crystal clear that we don't lose our privilege, but your examiners can review privileged material on our premises without making copies or taking copies with you. Some examination teams have accepted that solution. Others have said, we want the documents provided to us. Some of our clients have said, we're not going to fight with the new regulator on the beat, and they've just bitten the bullet and turned materials over. The good news is that in one of the few bipartisan efforts on the Hill these days, there is legislation moving forward to create protection for privileged materials that end up in the hands of the CFPB. It's not clear whether that will be an amendment to 1828X to include the CFPB or whether it will be an amendment to Dodd-Frank Title 10 that will grant the protections that the other banking agencies have.
Mike, one question on that. I have a recollection that there was a memorandum that the CFPB issued indicating that they believed that the protections accorded by X, while not specifically written into the statute, are nevertheless available, referring back to the days prior to the amendment to 1828 that provided X to provide the statutory protection. What's been the reaction that you've seen on that? On that,
I think that most of our clients don't believe that they've got the protection of 1828X. The CFPB's guidance is predicated, as I said, on a 1990s vintage OCC interpretation and a Hawaiian District Court case that predated 1828X. If those two pieces of authority really protected banks when they turned privileged information over to their regulators, I don't think we'd have seen the need for an 1828X 5 years ago or 6 years ago, whenever it was enacted. And the CFPB in that same guidance said, by the way, if you refuse to turn privileged information over to us and you cite privilege as the reason for withholding documents, that's not going to be a valid defense, and you may be facing an enforcement action. So
that's my next question. Are we seeing any enforcement actions or threatened enforcement actions because banks are reluctant to provide the information without some higher level of comfort than a district or an opinion by the general counsel?
We haven't seen any enforcement actions among our aimed at our clients, but that's because I think our clients have worked out other solutions, like sharing them on site or just biting the bullet and turning them over.
And hopefully we'll have a legislative fix in the near future. Then again, we all know how quick things move in the House and Senate. There are actually, of the proposals out there, as Mike mentioned, the original proposal in the House was to amend Title 10, and then somebody must have realized that it may have been a better idea to make the amendment to 1813Z, which defines what a federal banking agent. Actually, it's to 1828X. 1828X, the proposal in the House and the Senate currently is that 1828X would, every time it refers to a federal banking agency, it would say the CFPB and the federal banking agencies, and so that is the way they're currently looking to to amend the provision.
Kent?
One question about this privilege issue. But classically, I think of the supervisory agencies as having a cone of silence around them, so that if you give a privileged document to the OCC or the FDIC, it stays with that agency. And that's part of the concept of this even common law pre-1828X protection. But the CFPB is sort of a different animal. They've got a lot of joint enforcement authority with the attorney generals, and I'm wondering if that difference has sort of worked its way into the legislative
Well,
dynamic and what people are saying about that.
yeah, the question is.
Yeah, Mike, if you could repeat Kent's question, that would be great.
Yeah, the question is that bank supervisory agencies have, as Kent put it, a cone of silence. I mean, they don't generally make their examination materials that they've gathered as part of the examination process available to the public. In fact, banks are not allowed to share supervisory information generally outside of very limited circulation. But the CFPB is a different animal. The CFPB has authority to engage in joint examinations and investigations with state AGs and other third parties. So the same cone of silence doesn't really exist, and I think that's one of the reasons that everybody is grappling with. You know, if we turn privileged information over to the CFPB and they share it with the state AG of New York, you know, is that a roadmap to some enforcement action that a state AG is going to bring against an institution? I think that's why this has become such a hot button question relatively soon after the CFPB began to actually exercise its examination powers. I just real quickly want to go through some definitions that are in Dodd-Frank that affect fair lending. For the first time, the Dodd-Frank Act defines fair lending statutorily to mean fair, equitable, and non-discriminatory access to credit for consumers. It remains to be seen how the standard is going to be applied by the CFPB, but it does suggest that there is a suitability standard that is going to be applied, and that institutions are going to have to steer their customers not into subprime loans as was occurring in the past, but rather steer them into the product that is best for them. There's almost going to have to be some suggestion that institutions are going to have to substitute their judgment for the judgment of customers. I think that's one of the big fears in the industry. There's also a new standard. Section 5 of the Federal Trade Commission Act has long prohibited unfair and deceptive acts and practices, and the banking regulators have, for 20 years, used Section 5 of the Federal Trade Commission Act as authority for prosecuting UDAP cases against the regulated banks. For the first time, there is a statute that applies specifically to financial institutions, and it's Dodd-Frank contains a provision that says an act or practice may be abusive if it materially but the Dodd-Frank standard not only is unfair and deceptive acts or practices, it includes an abusive standard. So it prohibits unfair, deceptive, abusive acts or practices, and no one really knows what abusive means. There's a statutory provision that says an act or practice may be abusive if it materially interferes with the ability of a consumer to understand a term or condition of a financial product or service, or an act or practice may be abusive if it takes unreasonable advantage of a lack of understanding on the part of the consumer of the material risks, costs, or conditions of the product or service. or the inability of the consumer to protect the interests of the consumer in selecting or using a financial product or service, or the reasonable reliance of a consumer on a covered person to act in the interests of a consumer. That last bullet point is pretty interesting. Does that create some sort of a duty on the part of a lender to to some sort of a fiduciary duty to make sure that the product is the most suitable product for the consumer? Again, no guidance has been issued on this. When I talked to Peggy Toohey at the CFPB last fall, she said that they had so many priorities at the CFPB that they would be getting to this, but they hadn't put it on their short list at that time. So we'll just have to wait to see how the CFPB begins to interpret all this. I mentioned that the banking regulators for years have used Section 5 of the Federal Trade Commission to bring UDAP cases, and UDAP cases often morph into fair lending cases, especially where members of protected classes are disproportionately disadvantaged by whatever the alleged unfair or deceptive act or practice is. So I think we're going to see more fair lending cases that start out as UDAP with a double A and end up as a fair lending matter.
Well, that's the walk of the park with fair lending. There's obviously much more that we could go through and drill down on this. We have a few minutes for questions, comments, observations. Kathy?
Yeah, I wanted to ask, could you just confirm a little bit about how the state laws interplay with some of it? I mean, for example, New York state law, anti-discrimination credit law is broader, has a more protected classes than the federal law.
Well, if you're state what's the interplay between the federal fair lending laws and the state fair lending laws? I think that if you're a state institution, clearly you have to comply with both state and federal laws. If you're a national institution or a federal savings bank, there's an argument that state consumer protection laws may be preempted. That's still in a state of play. And plus, the state AGs under Dodd-Frank have more authority to get involved in investigations. And so far, none of this has transpired, but it's only a matter of time.
Yeah, I think it's certainly the view of the banking industry that the preemption provisions in Dodd-Frank really don't change the state of play a whole lot. I mean, they obviously have an impact on subsidiaries, but the basic thrust and breadth of them is such that it's not obvious to a lot of people that they change dramatically what the world was prior to 2010. You've got the CFPB in place now. CFPB's got a different mandate. CFPB, I don't want to use the word unholy alliance, but they have an alliance with the state AGs in a way that is going to make some of the sort of the thrust that exists on the federal side over the years to have a preemption construct. I think that's going to become more difficult to see that continue going forward. I think what we're going to see is things getting polarized fairly short order, and I suspect for those of you who were involved in this litigation, there's going to be litigation as to what the breadth of the preemption provisions are in Dodd-Frank and how the provisions in Title 10 involving the CFP are going to be utilized.
I know a number of banks in New York that had mortgage banking subsidiaries have rolled up that business directly into a bank.
Yeah.
To avoid that issue.
Yeah, that's a fairly common structural issue, though, that all of us are facing with our clients that have had subsidiaries, both FSB subsidiaries, national bank subsidiaries, and what do you do with them? Where do you put them? How do you restructure them to maximize the ease of the sort of the elegance that they had of the sort of the ease of one set of statutes, one set of documents that they could deal with, and it's sort of a lot of folks are realizing that, oh my God, that's changed now, hasn't it? And you say, yeah, that's changed. And is there a way around it? Not really, not on the subsidiary issue, but it's going to be a big issue, I think, going forward. See if I have any questions here from our friends in the ether world.
There seems to be a line of thought that the effects test doesn't apply under COA and that it was improperly imported from the employment statutes, and I was wondering what your thoughts on that are.
Well, there's an argument that it doesn't because the language in COA is not specifically the language that's in Title VII of the employment laws. The agencies have long taken the position that disparate impact is a discriminatory standard that they can enforce, and nobody.
I mean, is anyone fighting that now?
No. Institutions just do not litigate a COA or Fair Housing Act cases. I wish they would. I think some of the DOJ settlements might have come out differently if the institutions had been willing to litigate.
But we have seen several civil suits dismissed because of the Walmart versus Dukes case and the way that could apply to fair lending. But the DOJ, I think, has taken the position that may not apply to them.
Here's two questions, if I could, from the webinar participants. What is your advice, recommendation on handling CFPB requests to prudential examiners for materials, exam results, responses, etc.? And then I think it's the same person. Since these are examiner the materials, potential regulators hold the privilege and may waive. Can a bank refer the CFPB back to the prudential regulator? Makes for awkward situation. Are you seeing this with your clients?
We've gotten reports from our clients that where the information that's being requested is examination material that the regulators believe is the property of the regulatory agency. We've actually been told that some of the bank regulators have said, don't give it to the CFPB. If they want it, they can come to us. So I haven't dealt with this on a lot of occasions, but I've gotten indications that the bank regulators are saying, don't give our materials to the CFPB, tell them to work through us.
Anyone else? Comments, observations?
Another question. I think with fair lending, the devil is in the details. And one of the things that I've heard recently is for years and years and years, the control group that you tested against was non-Hispanic whites. And I've heard that the OCC is now using as a control group all races combined against the minority they're testing about. Have you heard of that?
I have not, no.
Can you just repeat the question?
The question is, for these statistical analyses and the evaluations done by the OCC, the control group has historically been non-Hispanic whites in the context of doing a minority versus non-minority analysis. And is that changing to one where the control group is all races? I haven't heard of that at this point.
And related to that is the different regulators have different focuses, different views, different ways of analyzing data. And would you want to talk a little bit about what some of those differences are? Because it's very frustrating if you're in a large financial institution that has banks that are regulated by the different regulators to come across these different methodologies.
So the question is, when you have subsidiaries that are regulated by different regulators, OTS, OCC, or what was formerly the OTS, so OCC, the Fed, etc., they do have different ways of looking at things despite the what is supposed to be an interagency fair lending examination procedures. All I can say is, yes, they do have different approaches. Hopefully, with the CFPB taking up a lot of that space now. We'll have some more consistent approaches to this, but right now that is not the case, and we tailor our analyses to who the regulator is for that entity.
Okay. Well, we're running up against the appointed hour. We appreciate your participating here with us. Okay. We have we'll pick up on these seminars again probably as things get a little bit clearer with Dodd-Frank on some of the areas, particularly Volcker, and I think we'll be looking at one on the enhanced supervision provisions for Title I when that gets a little bit clearer as well. But I want to thank my fellow panelists and thank all of you in the audience and in the ether via the webinar. And if you have any questions, please feel free to email any of the panelists, not including me. It's not something I really spend a lot of time doing, but Mike and Jeremy and David really are the experts, and we'll try to get back to you as quickly as we can. As to those of you who are on the webinar, I know there's been some difficulty in trying to get things printed out. We will make every effort to email the materials out to each of you so that you have them, and you should be able to readily, they're all in a PDF file. You should be able to print them out without any difficulty at all. So thank you for your participation and your questions and your attention. Thank you. Let me introduce my fellow panelists, if I could. Start at the far end. David Kogut is a principal to Charles River Associates in Washington. He's an economist and is spent a lot of time working on fair lending issues. Next to David is my colleague Jeremy Hochberg from our Washington office, who, along with David and Mike, have worked a great deal on fair lending issues. Next to me is my partner Mike Marzuski. Mike probably has as much experience as anybody in the country on fair lending issues, and really is a wealth of knowledge in this whole area. So without further filibustering on my part, let me turn it over to Mike, who's going to start us off and provide us with a bit of an overview of what's going on. Mike?
Thanks, Pat. Good morning, and thanks everybody for attending this webinar, and also for those of you who are here in person. As Pat said, fair lending has sometimes taken a back seat to Dodd-Frank and some of the other highly publicized financial regulatory developments of the last couple of years. But fair lending has not really been dormant. In fact, within the last 5 years or so, the way that the agencies have examined for compliance with fair lending has changed dramatically. And I think with the creation of the CFPB, which I'll come back to at the end of this presentation, the examination and enforcement of compliance with the fair lending laws is not likely to lessen anytime soon. 5 years ago, the state-of-the-art fair lending monitoring tool was a high-level screen that analyzed HMDA data for outliers, and if there were no outliers present, the examiners generally closed their examination file and moved on. Today, that's not the case, and if you haven't had a fair lending examination at your institution for a while, you may be surprised at how robust the fair lending analysis is. The agencies now use very, very sophisticated computer models to do regression analyses to determine whether there are statistically significant disparities.
Good morning. We're starting a new tradition. We're starting on time, which is something we don't always do. But welcome to the 14th in a series occasional series, it appears, of discussions on the financial services industry. Today we're going to take a slight detour from what we've been talking about in the relatively recent past and really focus in on fair lending and as the title indicates, best practices for complying with the fair lending laws. Pretty clearly over the past weeks and months, almost coming on 2 years now, the thrust of the regulatory environment has been in large part Dodd-Frank and the implementation of the Dodd-Frank Act, or the lack of implementation, depends upon your perspective, I suppose, and sort of the mortgage servicing issues surrounding mortgage servicers, both the gigantic case the government brought against the 14 largest servicers, plus the examination of servicers that is continuing to go on by the examination staffs of the agencies, and there's been certainly a lot of news, litigation, discussion, conversation about the general retail mortgage backed securities environment. Seems like everybody is suing everybody in this, whether it's the sellers, the buyers versus the sellers, it's the mortgage insurers versus the packagers. Apparently, nobody realized there was gambling going on in the back room, so this will be something that will be sorted out over a number of years. But pretty clearly, one thing that may be a little bit off the grid with all the other things that are floating around is the continued, and I don't want to say re-emphasize, I want to say continued focus on the part of the government to look at fair lending. This has been something that's been there. It's an area that the government has spent a fair amount of time focused on, and today we're going to try to do a fairly in-depth analysis of just what the government's been looking at, what you can do to prepare your institutions for the examination process, as well as any issues that might come up in that process. And we're very lucky today to have, I think, a terrific group of folks who've got a great deal of experience in the fair lending world.
Somebody because they rely on public assistance. There are certain exceptions. The ECOA does permit creditors to favor elderly applicants with more favorable terms and conditions than are available to other similarly situated younger individuals. The second major federal fair lending law is the Fair Housing Act. It prohibits discrimination, again, in all aspects of a residential real estate transaction, including the granting of credit, and it prohibits discrimination on slightly different bases than the ECOA. It prohibits them on race and color, national origin, religion, sex, familial status, which isn't covered by ECOA, and disability, again, which isn't covered by ECOA. The ECOA and Fair Housing Act both apply to residential real estate mortgage transactions, but ECOA also applies to all types of lending, including non-residential lending. So, for example, if you have a female-owned small business that comes to a lender with an application for credit, that lender can't turn the application down solely on the basis that they don't make loans to women-owned small businesses, or they don't make minority-owned small business loans. So it's important. A lot of people forget that ECOA does not just apply to consumer transactions. The OCC has published a list of examples of discriminatory conduct. Among them are failing to provide information or providing different information regarding credit availability with respect to application procedures or lending standards, or discouraging or selectively encouraging applicants. Many institutions employ mystery shoppers who visit branches and seek information about loans, seek assistance with filling out applications for loans, to see if white mystery shoppers are treated differently than mystery shoppers who are members of protected classes. So again, it goes back to the point I made earlier about being careful in all aspects of a lending transaction, including the initial contact that somebody has with bank lending personnel. The OCC also believes that making loans on different terms, including the amount, interest rate, maturity, or type of loan, when similarly situated borrowers are involved, can be enforced nearly 20 years ago. And lastly, there's non-discrimination requirements that are contained in what are now OCC regulations. Interestingly, this is a OTS regulation that prohibits discrimination not just in lending but in all aspects of banking products and services. When the OTS was subsumed in the OCC last July, the OCC recodified the non-discrimination requirements in 12 CFR Part 128. Interestingly, that only applies to thrifts. It does not apply to national banks because it was an OTS regulation and the OCC did not amend it to include national banks at the time that it recodified it. The Equal Credit Opportunity Act is probably one most people are familiar with. It prohibits discrimination in any aspect of a credit transaction. What's particularly important is to pay attention to any aspect of a credit transaction. That means it covers everything from advertising to your first interaction with a consumer, all the way through servicing, foreclosure, repayment of a debt. And I think a lot of people focus on ECOA compliance from the perspective of denials or pricing or terms and conditions, but we've seen cases involving advertising that was considered to be discriminatory, applications and the quality of assistance that borrowers have gotten up front that have been deemed to be discriminatory by agencies. So it's important to take an expansive view of where in a credit transaction you are and how you're treating people to make sure that similarly situated people are being treated similarly. The Regulation B is now under the purview of the CFPB, which recodified the Fed's Regulation B without substantive changes. They have not modified that regulation or really issued any guidance or interpretation, so it remains to be seen how the CFPB is going to interpret the ECOA and Regulation B going forward. The Equal Credit Opportunity Act prohibits discrimination on the basis of race, color, national origin, religion, sex, marital status, or age, and it also prohibits discriminating between the way members of protected classes under the fair lending laws are treated versus the way that the non-protected applicants are treated. And David is going to get into some of the regression analysis detail later in the presentation. So there are a lot of good reasons to be diligent in trying to have your institutions comply with fair lending. First and foremost, it's the law. It's also good business practice. You know, there was a time 40 years ago when the white male-dominated banking industry didn't think single women should be able to obtain credit or didn't think minorities were good credit risks. I think that history has proved those outmoded notions wrong, and I think a lot of our institutions that we do business with and represent believe it's good business to have a diverse customer base. And I guess lastly, compliance with fair lending laws is important because the failure to comply has some serious consequences looming. The agencies have an arsenal of arrows in their quiver. They can impose injunctive relief. They can require restitution. They can impose civil money penalties. anyone accused of unlawful discrimination suffers reputational risks, and it also affects your ability to expand geographically if you have a fair lending issue that results in a downgrade of your Community Reinvestment Act or your compliance rating, or results in a referral to the Department of Justice or HUD. In effect, you're put in the penalty box until you have been able to clear your fair lending issue. There are basically four fair lending laws and regulations and guidance that we're going to touch upon today. The first is the Equal Credit Opportunity Act, which is implemented by Regulation B. The second is the Fair Housing Act, which is implemented by regulations published by HUD. The third is the Interagency Policy Statement on Discrimination in Lending, which was first promulgated in 1994. There's a lot of good information in that policy statement, but the way that that policy statement is enforced today is radically different from the way it was